14.
Yeah, that was 14. That's right. Okay. We have based our decision on the foregoing and the following constitutional and legal basis. Under the heading Supreme Court Decision in the Election Petition Number 1 of 2017, Raila Odinga versus IBC and others, in arriving at his decision to nullify the presidential election held on August 8, 2017, the Supreme Court made the following findings of illegalities and irregularities based on which the National Super Alliance Coalition proposed a 12-point irreducible minimum required to make the fresh election fully compliant with the Supreme Court decision. With regard to the statutory reforms, on the matter of the statutory reforms used in the elections, the court found that contrary to the assertion by the Commission that it had fully complied with the Constitution and the law, and the position taken by the Commission through the affidavit of Immaculate Kasait, that the Commission had developed standards for its electoral goods prior to their procurement, including specific security features for each ballot paper and statutory reform in order to prevent duplication, misuse, piracy, fraud, counterfeiting, and to improve controls, and that the statutory forms and ballot papers are the features which included Goliosha patterns, anti-copy patterns, watermarks, microtext, tapered serialization, invisible UV printing, polling station data personalization, self-carbonating element and barcodes, different color for each ballot paper, and that the forms were in a standard form or format. The scrutiny supervised by the Registrar of Supreme Court and authenticated by the agents of all the parties to the case had reviewed the following. A, the Commission declared Uhuru Muigai Kenyatta the President-elect before it received the results from 11,883 polling stations and from 17 constituencies. B, Form 34C, used to declare Uhuru Kenyatta President-elect, was not original, but a photocopy, and that no explanation was given as to the whereabouts of the original form, and that the form, as crucial as it is, bore neither a watermark nor a serial number. C, Forms 34B, used to declare Uhuru Kenyatta President-elect, were of dubious authenticity, and that some of the forms were photocopies, carbon copies, or were not signed by the returning officers. Out of the 291 forms 34B, 56 did not have watermark features, 31 did not bear serial numbers, 5 were not signed at all, were not in a standard form or format, among other discrepancies. D, out of a random sample of 4,299 forms 34As examined, a total of 189 forms are not been filled in the handover quote section. 287 forms are not been filled in the takeover section. 481 forms were carbon copies. 11 forms had no watermark, and considering the sample size, it is apparent that the discrepancies were widespread. E, the forms were not in a standard form or format. The Supreme Court ended its examination of this part of the judgment by raising the following question.